the fewer reports they're going to write in a year, because they're spending so long writing one, they just think, well, I don't want to do this all the time. And we don't have enough writing doctors for the demand, and it is a huge problem. Who can change this? I think I would love to be able to change it. I don't see how you can change it when you're too low down in the power structure. It has to come from the top, I think. So you're the lawyers, you know, it has to come from the top down, that you don't need this amount of medical evidence, this level of complexity in the medical evidence. It's not the required standard of proof, so it shouldn't be demanded. And as you say, it's not fair to all those who can't access even a small amount of medical evidence. There are many cases that could be decided without a medical report, and yet, because it looks like a great story and the person's covered in scars, someone's asked for a medical report just to say the same thing. And that doctor could perhaps have been better employed writing the report for the person with the very thin-looking, weak-looking case who doesn't have any physical evidence. That's the person who really needed medical help.
I think that, a terrific question and a problem we all think about as advocates. In Greece, an organization recently has started offering certifications of torture under the Istanbul Protocol, but they can only do about 20 per month, and there are 10,000 refugees in Greece. And so now the Greek Asylum Service has decided that these certifications are really valuable in cases, and people who don't have them must not have been tortured. So we have exactly the problem you're talking about in Greece, and absolutely a person's testimony alone should be sufficient to establish a claim for protection. And I think as advocates, we all have to argue that. As you may have seen, we recently had a scandal in the United States with a woman who was claiming that our new Supreme Court Justice Kavanaugh had been inappropriate with her, and there was a big debate about whether her testimony alone was enough. So we grapple with it in the United States, it's an issue in Greece, it's an issue in the UK, all over the world, here in Hong Kong. And I do think that we have to always return to that core principle that the individual who we're representing is enough evidence. Their testimony alone is enough evidence, and we have to start with that baseline. The other thing that we have done in some countries is we've had experts develop reports that are general about an issue that can be shared with advocates to utilize in cases. So maybe in Central America, where we have sort of an epidemic of rape against women by gang members, those experts can go in and document that systematic rape of women in Central America, write reports about the phenomena that exists, and make those reports available to anyone, any advocate who's representing a woman from Central America who suffered sexual violence. So even though it's not specific to a case, it bolsters her testimony because it corroborates her testimony. It basically says, here's what she says, here's what's going on in the country, you match them together. So that's kind of an intermediate step. It's not an individualized medical report or evaluation. But I absolutely agree with you that we don't want to set the threshold or the bar high. I work for a private law firm and we can pay for evaluations, but many nonprofit organizations cannot. And so we definitely get this kind of pushback, but we also try and then support those nonprofit organizations.
We have time for one more question, if anyone wants to put in the last inquiry. Masha.
It's far away. It's in context of asylum claims, right? But in the countries that we were discussing in the previous panel, sort of the right to medical report, it's part of your right of access to justice, right? For example, I live now in the United States, but I'm from Kyrgyzstan, and colleagues in Kyrgyzstan managed, after many years, to get medical report, Istanbul Protocol to be adopted as a form by the Ministry of Health. There are discussions about it. I know the same exists in the Philippines. So anybody who alleges mistreatment has a right to have a public health doctor to be assessed with regard to this form. Is it with holistic evaluations that are appropriate? Probably not, right? Like we struggle with that a lot. But on the other hand, knowing that a lot of evidence will go away, and if and people might like sort of not be able to complain or recover this evidence later. So like in this sense, we think that yes, like there should be right to the medical evaluation in every case, right? And we struggle between initial medical examinations that any detainee should have and like a full evaluation that you do if you allege any mistreatment, or should everybody has this full evaluation, because it's very hard to allege mistreatment in detention, right? Like you will be singled out, like, and like in Kyrgyzstan they're going towards even this model, but like resources don't exist. Like, so we struggle with that as well, but like the right, how much it means of access to justice is like very critical.
I'm curious, Marsha, so it is now mandated that people automatically have access to this medical assessment if they're the victim of...
I mean, there is a medical form that should be used for every person in detention. There is like not enough personnel, doctors are not trained enough, etc. But since that adoption, we had first ever case in the country, because the form also says it should be confidential, and of course police is always present during medical evaluations, like of course they sit there. It was the first time ever a medical examiner brought a case for the intervention with her, into her profession, right? She asked police to leave, police didn't leave, and she filed the case. So like it's mandated now, it's not effective yet at all.
Yes, because my question was about, has it affected the quality of the reports, or is it not really effectively available to anyone?
There was nothing before, right? We're talking about Kyrgyzstan. We had first convictions, right? I'll give these reports to Juliet and you'll destroy them in seconds, right? They're not good reports. But there was like, what was before you come in, the doctor says, are you okay? You are not okay. I don't see bruises because we even didn't like take your clothes off. You're done, nothing psychological, nothing else, right? We don't want to hear your story. We want to see if like your leg is missing, maybe then we'll notice it, right? So this paradigm changed, but we're of course starting from a very different reality, right? From somewhere where it's more migration. But I would argue it's starting changing the paradigm. It will take decades. Right?
Very interesting. I'll thank Juliet and Jane for being here today. They're both significantly jet-lagged. If they belie it completely, you wouldn't know, of course, because they're the consummate professionals. But also to thank you both individually for the work that you do. You're both pioneers in your field, and we all have a lot to be thankful for the ground that you've forged. So on behalf of all of us, thank you very much for being here, and thank you for your work. Okay, I've been informed we have time for just 5 minutes to stretch our legs, take a break, go to a bathroom before Dr. Juliet Collin presents on the last item of our agenda today.
Yeah, because there's a number of talks on this. I'll leave it
If I can get everyone to get seated for our last session for today. So, the symposium will talk about best practice, and now we are going to circle back to one of the topics that we had earlier today in one of the breakout sessions, being detention and detention of torture survivors. One thing that most jurisdictions that people practice within here probably are guilty of, and certainly an issue that is global and regional and local. But we are excited that Dr. Juliet Cohen is here to present to us what is the first public reveal of a new set of guidelines for torture survivors in detention in terms of healthcare and access to health in general. So without further ado, I'll pass the mic on to Dr. Cohen.
Thank you, and it's such a pleasure to be back in Hong Kong, because this is actually where my whole career in this field started in 1990, when I came to Hong Kong for a year and didn't have a job. And I ended up with a locum job for the British Red Cross at High Island Detention Centre, looking after Vietnamese refugees. And I didn't know what to expect. I'd never done any work like this before, but in the lunchtimes I would chat to the interpreter, who was a Vietnamese lawyer, and he wanted to ask me finer points of English grammar, because every evening he would be teaching English to all the other people in the camp. And as we got to know each other, he then decided to show me his application to be treated as a genuine refugee and not an economic migrant, so that he could rejoin his relatives in Canada. And he had a long, long statement, and it was all about how his father said this and his grandfather said that, and he had written about the other thing. And there were just tiny references to a detention here and a police station there. And I said, well, what happened when you were there? Oh, I don't want to talk about that. But shouldn't you? I didn't know any asylum and immigration law at that point, but I kind of just instinctively thought this might be relevant. And he didn't want to talk about it, because he wanted to be judged on who he was and not on what he suffered or how much he suffered. And that was my entry into this work. I won't tell you the rest of the story because we're so short of time, but it did all begin in Hong Kong, so it's lovely to be back here. This work, as I say, it is new. It's currently going to the board of the Faculty of Forensic and Legal Medicine in the UK, and if they give their initial approval, it will go out for consultation to the membership. We will be seeking some external comments and endorsements, and then hope to circulate these guidelines as widely as possible. What are they? Well, quality standard, this is kind of what I'm going to skim through, what quality standards are, and why they've been developed, and what we've actually set out. So quality standards are something that's referred to in the UK by the National Institute of Clinical Excellence, in particularly clinical terms, to address priority areas where there's a variation in quality of healthcare. And the reason that we've adopted this format is because we've become so concerned at the extraordinary variation in quality of healthcare in our immigration detention centres, where things are happening and have happened that just really make your hair stand on end. And this is happening in the UK, where we have regular inspections and unannounced inspections of places of detention can occur. There are visitors groups who go in. You would think that these things could not happen, and yet repeatedly they do. I saw a young man who was feeling more and more mentally unwell throughout a 6-month detention, and finally he decided to hang himself. And luckily his friends found him and cut him down and called for healthcare to come and look after him. And they said, oh, you look like you're fine, you're awake now, and they walked out. But his friends were so concerned about the fact that he couldn't speak, he couldn't swallow, he couldn't move his neck, that they called an ambulance. The paramedics tried to get access to the detention centre. Eventually they were granted access. They came with the member of staff from healthcare, who still said that he was fine and didn't need to be admitted. It took him 10 days to get referred to a mental health nurse, whom he didn't see for another 2.5 weeks. He asked for a soft collar because his neck was so painful, and he was refused one. He was reported as being on a hunger strike because he wasn't eating his meals in the canteen, because he couldn't swallow solid food. And then he was accused of faking his hunger strike because he was observed buying sweets and soft drinks in the camp shop because he couldn't swallow anything. And all of this was in his medical records when he clearly had sufficient injury that he should have been admitted to hospital for treatment and observation. So this is the sort of thing that is happening every day in our immigration detention centres, and why we felt that we needed to do something more. So what these standards set out is kind of a very clear distinction of what needs to be done, why it needs to be done. And the why is really important, because the why we felt was one of the missing pieces in the puzzle. Why is it that qualified doctors, qualified nurses are not doing what seems self-evident? If somebody came into a GP and said, oh, I've got this really sore neck and I can't move it and I can't even swallow, it's so painful, they would get treatment, they'd get referred on. Why is that not happening just because they're in a detention centre? What is it they don't understand that is meaning that they're so negligent? How should they do the right thing? And how can we know that it is being done? So we set up this working party. The core membership is from the Faculty of Forensic and Legal Medicine, but also Freedom from Torture, which is me with two hats on, but Helen Bamber Foundation, which is a similar organisation to Freedom from Torture, a group called Medical Justice, who send doctors into places of detention and see not only victims of torture, but anybody else with healthcare needs, and all of these other good people. That's just some background about immigration detention in the UK. There are over 30,000 people passing through every year, comprising foreign nationals who are awaiting deportation, but also a big chunk of asylum seekers who may be new arrivals or people at the end of process awaiting removal. We don't know how many of them may be victims of torture. Certainly it's not just a percentage of the asylum seekers, because many of the foreign nationals will also be people who are victims of torture. Perhaps that's what led to them being sentenced for a crime. So, for example, if you are a Vietnamese kid who gets convicted of being in a cannabis house in the UK, or caught up in a nail bar and convicted of prostitution and illegal working, you'll go to prison for that. But you may also have a valid asylum claim because you've been tortured and exploited by those who trafficked you to the UK. So there's a whole mixture of people. There's a lot of concern. There's a lot of cost involved, unlawful immigration detention settlements, 4 or 5 million per year being paid out to multiple claimants. So there's also indeed this huge numbers of self-harm and suicides, which seem to be increasing in the last couple of years. There are safeguards, there are supposed safeguards that victims of torture should not ordinarily be in immigration detention because it's an administrative detention. They haven't committed a crime just by seeking asylum. But there are all these areas of failure, as I've been describing. There are process failures, training failures, this terrible culture of disbelief. If somebody's in prison, well, they must be guilty. If they're guilty, they're a bad person. Bad people lie. Therefore, I don't have to give any credence to what they say is wrong with them, because they're obviously lying. They're attention-seeking, they're trying to manipulate the system, there's nothing really wrong with them. We'll give them a paracetamol and tell them to pee off. And that seems to be the prevailing attitude. We've even got a problem with a disputed definition of torture. So instead of going with the what's good enough for the rest of the world 1984 UN definition, we've had various legal actions, and this year in Parliament, the Home Office managed to get adopted an even more restrictive definition of torture, requiring evidence of being under the control of the perpetrator and powerless to resist what is happening. And these additional layers have meant that even more people fail to be assessed as victims of torture and therefore vulnerable to the additional harm of detention. So for the purpose of this document, we've adopted a much broader concept, because we've realized it's clear that while you can have these, legal definitions of torture, the sorts of harm that people suffer clinically can be sustained by other means. It doesn't have to be a state agent. They don't always have to be under the absolute control and so on. So we're using a much broader definition of serious harm and vulnerability to further harm in detention. And we hope that it will apply these standards not just to immigration detention, but to other prisons, to police stations, and other places where people are detained, such as psychiatric units. Well, you might say, why do we need this anyway? Aren't there already standards set out? And indeed there are. There are the Mandela rules. The CPT has set out standards for inspection of places of detention, victims of torture. There's a lot of guidance in the Istanbul Protocol. But if these standards were so great and so effective, why am I seeing what I see in the UK immigration detention centres? How could that be happening if we had all these great standards? There's something missing, I feel. Part of what is missing is that why and what exactly must be done and how should it be done? Because the doctors who are employed as primary care physicians. They don't seem to understand the very complex healthcare needs of this extremely vulnerable group. They don't understand how to care for them properly and how to do their job. So these quality standards are intended to be a user guide to enable them to do the right thing and to enable others to check if they are doing the right thing. We've talked a lot today about the effect of torture and how it destroys trust in authority and affects people's health in all sorts of ways. And I think anyone who's worked with the prison system knows that detention anyway has a lot of adverse effects on health, whether or not you're a victim of torture. But detention can also specifically re-traumatize the torture survivor because it can be so like the place in which they suffered their torture. So there are very complex healthcare needs, and these outcomes in terms of health are aggravated by the length of time people spend in detention, the fact that the healthcare services are poor, and that the person may themselves, in fact, avoid going to healthcare because they see the healthcare as part of the authorities in whom they don't even have any trust. So there can be all these different factors re-traumatizing the person and leading to an exacerbation of their PTSD-type symptoms, which changes their behavior, particularly in terms of angry outbursts and self-harm. Behavioral problems that can lead to them being punished. So we see people who've kicked off and behaved badly, got into a fight because of their trauma, and what happens to them? They get put in segregation. What does that remind them of? Being in solitary confinement. Their behavior gets even worse. Their mental health deteriorates. So healthcare professionals actually have all the responsibility in this, and it's very disturbing and distressing to me the extent to which they're failing in these responsibilities. They have the responsibility to identify the victim of torture, to identify their healthcare needs, to facilitate a trusting relationship instead of one where there's no trust, and to identify in particular those who are unfit for detention, particularly where it's an option as it is in immigration detention. And in particular, they have this responsibility to follow the ethical code, that they need to put the needs of their patients above the requirements of any third party, such as the detaining authority. So these are the 12 areas that we defined as being in need of attention. I would definitely put you all to sleep if I went through all of these individually, but I have got some information about all of them, and I'm going to kind of skip through so you get just a flavour of how we've assessed these different quality standards and what follows from them. The most important one, I feel, actually is the first, disclosure. All of the quality standards follow this format, so there's a statement in which the purpose of the standard is defined, the rationale, which is the why is this a problem, why should we care about this, why should we do more about it, and then the quality measures, which are defining what needs to be done, and the quality standards, which are how we do it, how we can see it's being done. And also in the document, we've included implications for the stakeholders who are the commissioners of healthcare, the service providers, the healthcare practitioners, and the service users themselves. So the first one is disclosure, and the statement is that detained victims of torture are helped to have their healthcare needs met. Where possible throughout the standards, we've referenced the existing standards, such as in the Mandela Rules and in the Istanbul Protocol and so on, simply to provide the platform from which these standards take off. It does seem to be that facilitating disclosure is something that people are just not very good at. They don't want to go there, they don't want to spend the time, and these are areas that we identified as being very, very important. If you're going to facilitate disclosure, you've got to create a decent relationship. Everybody needs to understand what they mean by consent and confidentiality, and you have to use an interpreter if there's any communication challenge at all. Gender considerations and time and so on are also very important. And privacy. Too many of these assessments are taking place within sight or hearing of detention officers, and you can't expect people to disclose what's going on if that's the case. There's a long list there, you can't read that, don't worry about it, but it's in the document to try to prompt people to make that full assessment, to think about what might be a clue to past torture, to explore all these different things. So it's very clinical, I make no apology for that. This is a document aimed for doctors and nurses. And the other thing that we found they were doing was that they would identify that someone was tortured, often because the person said, I've been tortured, and then they don't do anything about it. They just write it down. So constantly I would see in the healthcare records or in this Rule 35 report, which is the supposed safeguard to enable a reconsideration of their unfitness for detention, says they were raped 3 years ago. Nothing, and then nothing. So what about their mental health? Are you going to explore that? No, no comment. What about their healthcare needs? Have they had sexual health infection screening? No comment. Nothing done. If somebody comes into my general practice and says, I was raped 3 years ago, this is the first time I'm able to talk about it, those records will be very detailed. They will contain a full assessment because that doctor not only is understanding their job, but knows that there might be a complaint made if they don't do their job properly, and those medical records better damn well show that they did their job properly. And I think one of the problems that we have with detention healthcare services is that they feel they have complete impunity towards any complaint being made, any complaint about negligence. Otherwise, I don't understand how they can think that it's adequate to not comment on the sort of disclosure that I was raped 3 years ago, and then nothing, no care plan, no investigation, no advice, no assessment. This is what's happening routinely, and it doesn't make any sense unless you assume that this doctor has just put down the shutters. They think they are completely immune from any complaint. It doesn't matter that they don't investigate this. So we're specifying the need for a care plan which summarizes that healthcare needs have been considered, investigations have been ordered and review the outcome and review what's happening next, and consider specifically risk of self-harm, consider specifically if this person is unfit for detention or for particular processes in detention. And we spell it out all over again in a pathway just to make it more graphic. You need to have a care plan, you need to review, and you need to escalate concerns if you're not being listened to, because this is another area where doctors seem to be paralyzed from actually fulfilling their obligations. So then there's a list of quality measures that you need to be able to see that there's evidence that these things are actually happening. And then in the standards, this is a way of actually seeing, are they doing it? So you could imagine inspections being able to then do a dip sample and actually identify what percentage they're achieving of all of these different items. Another really important quality standard for me is the ethics one. I talked about this failure to escalate concern. So when doctors work in a detention center, they seem to lose touch with how they would treat people normally, and this idea that they have to put the needs of their patient first gets lost. So they need to understand that the same standards really should apply to every other patient that they would see in other practice. And they need to speak up when things go wrong. They need to support colleagues to do the same. This is not new. The Istanbul Protocol expresses it very clearly, but still it's not happening. So we've set out these measures. They need to be clear about the process for which they're seeing the patient. If they're seeing the patient to assess if they're unfit for segregation, it needs to be really clear why they're examining that person, so the person can consent to that examination or not. They need to maintain their contractual independence. They need to make sure that they're providing equivalent care, and they need to make sure that they're safeguarding vulnerable people. Again, there's a whole lot of detail in these standards, which I really can't go through in the time that we have available, but they do set out a way of measuring what's happening. And my particular concern is this process of escalation of concern, internally, externally if necessary, with whistleblowing policies, with named individuals to whom you must go and speak if something hasn't happened that you wanted to happen, if your concern has not been recognised. The third one is consent and confidentiality. Again, this is something that seems to be very poorly administered in detention. And I found when I looked at the standard consent form that's in use in immigration detention in the UK, that although they've got a lovely piece of sort of information at the front of it which says don't seek blanket consent, make sure the person understands what information is disclosed, who it's disclosed to, how it will be stored, when they actually come to the part that the person signs, they sign a form that says the information can be shared with anyone the Home Office want, including foreign governments and any unspecified parties. So essentially the information can go anywhere. Now, if that information on the healthcare contains, for example, the disclosure of their sexual orientation, and they're going to be removed to a country where that's illegal, how is that safeguarding that person? I mean, it defies belief that this is actually happening. I've referred them to the information controller in the UK, and I'm waiting to see what they do. I'm sure they're going to redraft it in some sort of way, but at the moment it's a really horrific pro forma that is currently in use, and patients who refuse to sign that get into a lot of trouble. And in fact, there seems to be a process whereby they can just override that refusal of consent anyway and share the information if they wish. So I think in human rights terms, this is a massive area of concern. Patients don't have a very good understanding of how to control their medical information, and they should do. But particularly for victims of torture, this loss of trust in authority is an even bigger one. And so I think it should be even more heightened for these very vulnerable people. So again, we set out these measures and standards of exactly what you should be looking for to see if proper processes are being followed. So when Stephen Shaw did his inspection of the welfare of vulnerable people in immigration detention in the UK, one of the things that was really shocking in the review that he did this year was that he looked up how many interpreter contacts had been used in each immigration centre in a month. Now, given that each immigration centre is containing people who tend not to be natural English speakers because they've come from other countries, and many of them don't speak English as a first language. Many of them haven't been in the UK very long. You would think that interpreter usage would be really high. And what it looks like when you break down his figures is that for an immigration centre housing several hundred people, there might be 4 interpreter contacts on any given day, 4 or 5. So how could those people be having adequate health care if they're not able to speak more than broken English to the person who's supposedly looking after their complex healthcare needs? And yet, this is all being tolerated. Oh, it's too difficult. Oh, we don't want to use that telephone system because they won't pay for live interpreters. Then all the contacts have to be done on a telephone interpreter system, but they're not even using those. They're just managing with broken English and expecting people to be able to disclose very, very complex healthcare needs and experiences. So there are a series of measures and a series of standards which really do need to be followed if people's healthcare is actually going to be in any way adequate. Another area of really important concern is mental capacity. Jane talked quite a number of times today about her experience working with people with psychotic symptoms. And certainly my experience of visiting people in detention is that this is an area that's dealt with very, very poorly. And really quite shocking examples of people with very serious mental health disorders being treated as attention-seeking, difficult, disruptive, manipulative, and so on. Very, very pejorative terms for people who are in enormous distress. One case I saw recently was so heartbreaking. This woman's mental health had deteriorated steadily again through several months of detention. She was on a self-harm monitoring scheme, so the detention officers on the wing were monitoring her bizarre behaviour and reporting it to healthcare, where she was inappropriately undressing in front of other people, where her roommates were refusing to sleep in the room with her because she was so loud at night and was accusing them of attacking her, where she was clearly suffering auditory and visual hallucinations. And so finally, after a number of reports like this, healthcare got a psychiatrist to see her. Psychiatrist immediately diagnosed her as suffering psychotic illness. With the psychiatrist, she agreed that she would take medication to help relieve her symptoms. She attended healthcare just for 2 doses of the medication, and then she stopped because she said they were trying to poison her. Well, anyone who's got any familiarity with psychotic illness, this is a very common disorder perception that people may be trying to poison your food or in some way try to harm you, and she just believed that healthcare, whom hadn't helped her really, were trying to poison her with this medication because she was already suffering a few side effects, so she was right, they were trying to poison her. So she stopped going. So then they just wrote in her records that she was non-compliant and disruptive and manipulative. They didn't do any of the baseline investigations that the psychiatrist had ordered because they stopped bothering about her. And when the psychiatrist came back a month later, she was obviously much worse. It was inhuman, the way in which she was treated. And to compound this, when the Home Office case owner rang healthcare to check whether she was fit to fly to be removed because they wanted to issue new removal directions, the healthcare professionals said, yes, she was fit to fly, because they had decided, because she wasn't taking her medication, her psychotic illness didn't count anymore. I know, I can see you just not believing this, but I've seen it in black and white. This is what they said. And so she was made fit to fly. So that's why I'm concerned about mental capacity, because it just doesn't get recognised. So we've, again, set out what should be considered, when it should be considered, how to assess capacity. Why does it go unrecognised? I think the language barrier, the failure to use interpreters, is a big part of it. There is a very poor continuity of care, the behaviour gets misconstrued, and I think the healthcare professionals are just outside their competence. That would be the most charitable explanation for their failures. So there's more information about assessment, the measures and standards. Access to healthcare, I won't go into this too much, but it's really about making sure that people who aren't coming to healthcare are not coming because they don't need to come, rather than because they don't want to come because they see you as hostile or because of their mental health problems. And checking that there's continuity of care if they're released into the community, for example. Vicarious traumatization, I think, is something that we should spend a bit more time on, and perhaps it could have come up in my conversation with Jane, because I think it's something that we all need to pay a bit more attention to in terms of our work, where we have to listen to people who've suffered these terrible experiences. It's not possible to do this work without some of it transferring to us and affecting us. And so you have to, if anybody thinks that they haven't been affected by their work, they haven't been traumatized, then they're not being honest with themselves, because it has to happen if we're doing this work properly at all. So we have to be honest about it and think about the ways in which it can affect us. There's a lot of different things that you can notice, perhaps in yourself, perhaps in your colleagues, about being over-involved or unduly cynical, having difficulty in managing caseloads, taking work home, missing deadlines. I've summarized them on the right-hand column in terms of secondary trauma with depression or PTSD, the savior syndrome, or the burned-out cynic. I think there are increased risks, particularly for people who work in detention settings. The doctors often work in relative isolation. They'll often be the only doctor in the prison at any one time, and they just wave to their colleague as they change shifts. The workload can be very high, and the training is insufficient. There are a lot of ways in which we can try to minimize this with strategies, both as individuals and as managers or lead clinicians. There are strategies that should be taken. So we've set out some measures and standards that should be checked, particularly about training and experience, having the right training for the job, maintaining that training, sending people on courses, multidisciplinary meetings to reduce the isolation and share difficult cases. And again, that process of escalating concerns, I think it comes into this part of the work as well. To reduce the vicarious trauma, we need to have something to do with our concern rather than just take it home with us. So training and competency is another really important area. And there's a list really here of identifying different areas of training that people should have, either before they take up the work or as mandatory training as they begin the work. And it's very simple to look at the standards. Has everybody got the training? If not, why not? Assessment for detention processes. So this is a really key one. There are ethical guidance which directs a doctor to consider specifically if a person has a medical condition that makes them unfit for the process in question, because it's not ethical to find somebody fit for something that will harm them. So you can't find someone fit for detention if they're going to be harmed by detention. You can't find them fit for segregation if they're going to be harmed by that process of being locked up alone. So the processes that we need to consider unfitness for are detention itself, segregation, control and restraint techniques, air travel, and I would also include interview, where people are going through interview processes while detained. So the doctors need to consider how past torture may have contributed to the need for the process. We've talked about behavior, how it may increase the risk of harm resulting from the process because of the re-experiencing, the triggering,